Hello, everyone. Uh, Good morning or late morning, depending on where you are, or late evening. It's I'm here to cover the breaking news on Julian Assange's case, development in the case against Julian Assange, the political case brought by the U.S. government and the British High Court of Justice, the High Court of Justice, which is at the Royal Courts of Justice in London, ruled against the ruled against Assange, overturned the district judge, ruled against the district judge, who made a very thorough, detailed, and what I thought was a decision that largely needed to be opposed because of what it said about Julian Assange and how it didn't allow him to be treated as a journalist, but ultimately spared him by deciding to block his extradition. That was earlier this year, back in January, on January 4th. I was here a little bit later, maybe, but around this time, reacting to a decision where Julian Assange's life was spared and the extradition did not get a green light from the district judge. We were now in this position. So thank you for tuning in. I'll just point out as a programming note before I go forward with some more reaction that you can go to thedissenter.org and get access to all of the updates and writings I'll be doing on the Assange case going forward, as well as older posts. And I've been doing coverage on this since he was indicted, and before that, covering in great detail the court-martial of the source who's behind the documents at issue in this case, Chelsea Manning, covering a lot of aspects of the war on WikiLeaks, which we know the CIA is largely behind now, thanks to the Yahoo News, Gray Zone, El País, covering the UC Global operation against the Ecuador embassy, and so on. So let's take that down, and also just let me share my gratitude to people who, when I wake up really early in the morning, are there to share this work, make sure others see updates, along with other journalists and colleagues who are out there who have shown support and are doing good work as well. And I've highlighted them. People like Stefania Marizzi, Richard Medhurst, the folks over at Consortium News, Mohammed Almazi, who's writing a piece for Jacobin, and others out there who are Juan Passarelli and others who are doing really good coverage and saying things that are important about this case, which is what we're going to need. You know, I think the news here is that the High Court has overturned this decision. They have sent the case back to the district court level, the Westminster Magistrates Court. I don't think it's going to be before Judge Vanessa Barretzer. I believe she's moved on to another position. So it'll be a new district judge who signs off. But I'm not even clear that we're having a hearing. What the High Court has asked this court to do, the Westminster Magistrates Court, is to send the extradition to the Home Office, to the Secretary of State, who will make the ultimate decision on signing off on this. And that's going to start the entire process in a very real way of Assange being prepared and potentially put on a plane to be brought to the United States. I mean, we are closer to extradition, much closer to extradition. If you want to have kind of doomsday clock in the Julian Assange case, the hand was maybe 20 minutes, 15 minutes before midnight. You can now move that hand to about 5 minutes before midnight, maybe 10 if we're being charitable. What this High Court did in co-signing all of the assurances to the court essentially is to say that people who are, well, if we just take it by their extradition treaty that the US has with the United Kingdom, that the US government is permitted to go before the district court and argue a case without addressing allegations of abuse or allegations or claims that human rights will be violated by the United States if a person is taken into custody. And we're not just talking about journalists. We're not just talking about Julian Assange. This is a case that potentially could be applied to all cases where human rights are at stake. We could see war on terrorism cases using this ruling. We could see the Crown Prosecution Service using this against people who are facing trumped up political charges in other respects. And what essentially is happening here is the High Court has said that in a district court setting, you can have an evidentiary hearing where witnesses are called and you can put arguments forward. And if you don't want to, you do not have to reassure the court until after the district court has made a decision that she believes the United States government will not respect the human rights or protect the safety and health of a defendant. And then, and only after then, do they have to come forward and offer assurances. And then those assurances must be requested by the district judge, and the district judge must review them. And if she does not, or they do not appropriately review those assurances, then they could have their decision overturned on appeal. So it doesn't make a whole lot of sense. You know, I can't think of off the top of my head another setting, an analogy, but it's really putting the cart before the horse. If you want to use an idiom from the United States, it's not something that should happen where you go through a court proceeding and the defense shows very reasonably that you cannot trust what the US government is saying, and then the district court does not find it reliable enough and then issues the ruling, and it goes to the appeals court, and the appeal court says you needed to give the US government a chance to respond to your decision against the US government in order to see if they could, at the last moment before you made your ultimate decision, convince you to do otherwise. That's not how I understand the legal process. And if anybody else has a better grasp of this, feel free to connect with me. But this is not how I understand extraditions are supposed to work. Those assurances should be offered in the extradition hearing that's before the district judge. And Julian Assange's team should have had the ability to know during that proceeding that took place in September 2020 that the US was going to make these sorts of claims that, he won't be put in a special administrative measures. He won't be put in a supermax prison. Oh, we will make sure he has mental health treatment and that a physician will refer him for any care that he needs. Oh, we will allow him to apply for a prisoner transfer to Australia. This was not something that was the subject of the proceeding. It's not something they were able to contest. The illegal team didn't have the opportunity to call witnesses and show the judge why you can't trust those assurances. And then we push it on forward to this appeal hearing, and they say, we've got these diplomatic assurances, because conveniently that means that you don't have to be concerned about anything the district judge said about why it will be oppressive to Julian Assange. You don't have to care about him. being put in danger, we take care of all of that. We have these assurances for you. And then they're pretty much tied up. There's not a whole lot that Assange's legal team can do in response. You can't call people at an appeal hearing to testify. The witnesses were supposed to be at the hearing at the district level. So, well, the best you can do is look at the record that was available and use older evidence and point out why you shouldn't believe those assurances and why you believe those assurances, if offered at the district level, would not have been reliable. And that's what they did. But this court did not believe it. And we had Timothy Holroyd, one of the justices, one of the lords, and then it was the Lord Chief Justice Burnett, who's apparently friendly with someone who was in Parliament who has called Julian Assange a worm. So that says something about the culture, the political culture. It's not much different from the United States. The judges and the politicians and the legislatures, and then as well as in the executive branch, and all parts of the UK government are in the same circles, in the same social circles. And so I have the decision. I will go through and I will break down the different parts of it in real time here. I'm looking at the decision for the first time, and if you don't mind, you can hang around and follow it. It's not going to be very, I'd say, very well constructed. I'm going to be doing a lot of it off the cuff, just kind of like reading through parts. But you're welcome to be in on that and see what I'll say before I start combing through this decision. Again, thank you to everyone who is tuned in. Thank you for those who are sharing this live broadcast. The important thing to say right now, this is the comment that I have. We have known all along that the only thing that will save Julian Assange is if President Joe Biden's administration drops the charges against WikiLeaks founder Julian Assange. We have known that if you want to spare Julian Assange's life, if you want to truly save him, it's going to require Attorney General Merrick Garland ending this political prosecution. It's going to take people in the Biden administration dropping the charges. It's going to take people in Congress saying, drop the charges. It's going to take a louder, more fierce opposition within the US press to shame the US government for taking steps forward that clearly would jeopardize freedom of the press. They need to speak up before he is put on a plane and brought to the US for his arraignment. We do not have that. Obviously, there are good reasons to be cynical about the possibility that any of the characters who populate our government will say a word against this case. Then that means we have to shame the Biden administration. I don't know if it can be shamed. It quite brazenly has allowed this to go forward, and the High Court issued its decision on Human Rights Day. It's Human Rights Day. It's an international day where the United Nations invites governments around the world to rededicate themselves to human rights, no matter what their records may be, from modestly inhumane to entirely brutal and repressive and violent to their populations. They've hosted a 2-day summit for democracy. Antony Blinken, I've been sharing the clip. I could play it again towards the end of this broadcast if you would like. But Antony Blinken is speaking about political prisoners, speaking about sham trials, speaking about climates of fear, and Orwellian legal systems at the same time that the Crown Prosecution Service has advanced this for them and succeeded. They played the system well. They knew exactly what buttons to push in order to get the High Court of Justice to give them the outcome that they desired. So they'll be asked to come back on for the next case and the next case after that. Some of the people involved, James Lewis, the lead prosecutor, he's shown that he's capable of moving this case forward with a very precise bit of contempt for freedom of the press. That's not too detestable, not too hard for judges to swallow, but just enough to get someone through the door of the airplane and brought to the United States. So they've succeeded in their job, and the Biden administration knew that these bureaucrats that they've enlisted will do this work for them, and so my focus is on my country in the United States. Why does this continue? And that is a question that we'll have to continuously ask ourselves and answer over the next weeks and months ahead. I expect that there will be some kind of effort at an appeal. I don't know what avenue is available. It seems like the High Court was trying to foreclose the ability of Assange to challenge this decision. And basically suggesting that there's a finality to it that, I believe the Assange team is going to have to make an effort to contest. They're trying to send it to the Home Office already, which the Home Office has authorized the extradition. So the Home Office is going to allow the United States government to get their hands on WikiLeaks founder Julian Assange, despite everything we know. And the corruption in this case is substantial. We have that the CIA is working or at least receiving audio and video footage from Undercover Global, this private security company in Spain that is conducting an espionage operation against the Ecuador embassy, targeting journalists, attorneys for Julian Assange, family members, going after them in conspiring to engage in acts of intimidation and harassment, and also committing such acts in the process of allegedly providing security to the embassy, eavesdropping on doctors, stealing medical notes in order to put them in dossiers. So they send a lot of these materials to the U.S. government that they have in their possession, the very government that is prosecuting Julian Assange, arguing for this extradition, has a lot of confidentially privileged information in their possession that they claim is siloed and separate. But, I don't know. At this point, I don't really trust them. So then, in addition to the CIA's plans, the discussions that happened, which we now know through Yahoo News with confirmation from sources, they were discussing kidnappings. They were discussing how to put him on a plane, rendition. They were talking about potentially killing him, disruption campaigns to turn people against each other, planting malware, so hacking into electronic devices, trying to neutralize and bring a media organization to its knees, which we saw very clearly and out in the open going all the way back to at least December 2010, when they responded to the cables that are published. They respond to the war logs that are published on Afghanistan and Iraq, all those cables on U.S. diplomacy. Then they're maybe responding to the Guantanamo files, but they didn't have such a visceral reaction to that. The collateral murder video, the video showing the Apache helicopter attack in Baghdad that murdered 2 Reuters employees and then killed a person who came in a van to try and save wounded individuals. All detailed, all very well known, all spoken eloquently about by Chelsea Manning in her court martial, and also the kind of documents that fuel journalism that won awards and is celebrated. And in addition to the CIA campaign and what they've done to fuel this case, we have the FBI. The FBI entering the country of Iceland on false pretenses, gaining access to the country in order to conduct surveillance of Julian Assange. They said they're there to help the government deal with a cyber attack. As it turned out, the agents, at least 8 or 9 of them, were there for another reason, and they got kicked out by the government of Iceland for lying to the government about why they were in Iceland. And at that time, not long after, they aligned themselves and work with and offer some kind of an arrangement to Sigurdur Tadarsson, who is a pedophile, who has preyed on underage boys, who embezzled funds from the WikiLeaks shop, who has made claims about his position in WikiLeaks that have proven not to be true, who has fabricated information, which is in the indictment that was brought before the district judge and largely taken seriously by her and now taken seriously by the high court justices. And so he is now in jail. He was put in jail to stop financial fraud schemes. And as far as I know, he has not been released. But if anybody has heard differently, I'll make a correction. As far as I know, he is still being kept in confinement to make sure that he does not continue to defraud other companies through schemes that have been investigated and followed closely by the authorities in Iceland. He's been diagnosed a sociopath, and the sociopath is the person who the FBI has leaned on as a key witness for the one section of the computer conspiracy charge that is against Julian Assange. That's in addition to the 17 charges of allegedly violating the Espionage Act. And all of these charges are recognized universally as violating any principles that you might have of press freedom. So there's all of that. The FBI through Ecuador was able to get his confidential archives from the Ecuador embassy. Those were seized by Ecuador and then passed on to the FBI. Materials could have been used by the defense to help them in this case. And so the corruption around all of this is fairly clear. The efforts that we've seen, not different and not lost on Pentagon Papers whistleblower Daniel Ellsberg, who thinks of what he went through and endured and sees this case and what a half century can do, because nearly almost exactly 50 years later, maybe a little less if you are going specifically by the dates of these actions, but around a half century later, this can all happen and be reported, and the US government get away with it. And then they can still posture at quote unquote summits for democracy as defenders of human rights and democracy and say that they support freedom of expression. And as far as I know so far at this 2-day summit, I'm not sure that Julian Assange's name has been raised. I haven't seen any clips, but I haven't been watching all of the sessions. So I don't think anybody has bothered to confront the United States on what they're doing. And we're here. We are here now. We have this decision. So I'm just going to take a look here. I will be very clear here because I see somebody. The fight does not end here is what Kristen Harafson is saying. He's the WikiLeaks editor-in-chief who took over for Julian Assange after he was detained. And yeah, I recognize that there's much more that the Assange team will be doing, and it'll be up to us to hope or stand by and support and boost those efforts. My interests in this are the same as the people at WikiLeaks. We want a world where we can have freedom of expression. We want a world where you can publish documents on the abuse and corruption of the United States and not face retaliation from the national security state. That we should set out as a marker that the reason why you should oppose Julian Assange's prosecution is because no country in the world should be able to use its justice system to pursue publishers who expose war crimes and torture and criminality, other criminality by the security or intelligence services or the military of that state. And that when the justice system is acting effectively as a deputy of those security agents, those intelligence agents, those military officers, that then they have undermined and ruined all ideas related to press freedom. And you can no longer claim to be a defender of press freedom and a defender of human rights if you are pursuing a case against journalists. No, I'm not here to sit here. I'm not here to sit here today and make judgments on countries that are considered enemies or adversaries of the United States. I'm not here to say, to equivocate and break down the array of cases that are on the dockets, political prisoner cases that Russia or China may have, Iran might have, other countries in Africa, Latin America, other parts of the world may have. What I know off of the top of my head is what my country does. I know what the United States government is doing. I know what is done to Julian Assange. I know that yesterday, Stephen Donziger was released out of prison after being imprisoned for months, for at least several weeks, if not a few months, because he won a decision against Chevron to hold them accountable modestly, very modestly, for the destruction of indigenous land by way of polluting their land with oil. And because Chevron did not want to be held accountable and did not want this negative public attention, they did not want the indigenous people of Ecuador to win, he was retaliated against, and a law firm tied to Chevron represented their interests, hijacked the legal process, brought charges against him, even though a prosecutor in an attorney's office did not make the decision to charge him, which is the standard. The Justice Department allowed them to hijack the process. The Biden administration stood by and did not say a word while this was happening. And he went to prison, and he's the one we are supposed to believe is the criminal, even though he did the utmost that he possibly could to defend human rights. And Antony Blinken and others in the US State Department want to go before their cameras and hop on Zoom and talk about political prisoners, sham trials, climates of fear, Orwellian legal systems. It's absurd. We shouldn't allow it. And we shouldn't let them be able to take the language we use to talk about real and actual oppression and repression by governments throughout the world and manipulate it in ways that serve them without them even really understanding the gravity of those buzzwords that they are using. Don't let them cheapen these words. These words have meaning, and we should stand up for those words to not be uttered by sniveling bastards in the US government who are doing this for purposes that are not aligned with human rights and freedom and principles of expression and for the sake of independent journalism. It's that clear. It's that clear. And there's really not more to be said. This is a litmus test. This is the litmus test. It's real. Today, it's even more real. It has been real. We have known that this is an attack on journalism, but it's made even more pronounced by the fact that it is getting more and more unlikely that the system in the UK will stop it. And those are for British citizens to discuss among themselves. Their government is doing this to an Australian journalist. I'm upset about it, but it's hard for me to be more angry about that than the fact that the reason this all started in the first place is that charges, a case that lay dormant, was revived by President Donald Trump's administration. Mike Pompeo pushed for some kind of action to disrupt and potentially hurt, kill maybe Julian Assange. And then the Justice Department said, well, we can't allow that to happen. That's extrajudicial, and we don't want that. So we'll issue these charges. And they charged him under the Espionage Act. And then now he's been in this legal limbo. I mean, he was in legal limbo, but he's been even more of this legal limbo from within Belmarsh prison. And his condition has been degrading and degrading and degrading. And so what do we do now? What do we do now? Well, okay, I need to get to the decision and read it. But let me tell you what we do now. What we do now is what we've been doing, if you've been doing it. And that's to say, we continue to do this work of covering journalists, of boosting journalists who are reporting on this case, like myself. I ask you to please continue to share and support the work that I'm doing to cover Julian Assange's extradition case, because it is far from over. But we knew it would be far from over if the U.S. lost, that they were going to appeal it to the next court. So that's something I'll just put out there so people recognize that it was not going to be over today for Julian Assange. Anyways, we're in a worse position now, and we need to continue to put all of this out there. We need to have confrontation. If you are in the United States, contact your member of Congress. Call the House of Representatives. Find your congressperson. Leave them a message. Let them know you care about this. They won't think that you do. They're not saying anything in their cop-out answer. If they really, they probably don't really want to say anything about Julian Assange, but they'll continue to cop out and not care about what you think, because they'll believe that that's not something that anyone in their district cares about. So keep calling them. Get them to say something. If you see them and you have a chance to actually ask them in a town hall a question, and you don't mind using your question to ask about Julian Assange, ask them about Julian Assange. If you have the ability to question any of these people who are in the Biden administration, if there are any forums or events that you go to and there's a Q&A and you get a chance to ask about Assange, ask them about Assange. We need these confrontations out in the open. We need clips that go viral that show that they, A, continue to refuse to answer these questions, or B, won't defend it. And then if by some chance we have the extraordinary turn where they do say something in response, then we're going to know immediately what their line is and what they've decided on as their talking point for behaving like this is acceptable, which it is not. It's my hope as we wrap here that, as I move forward with this live broadcast, it's my hope that there are leaders of different countries and there are people who are participating in the Summit for Democracy who are seeing this news and will bring it into the conversation. So the decision, which I have before me, is the judgment of the court. And this is coming from Chief Justice Lord Burnett. He's the one who has a good friend who was in Parliament who thinks Assange is a worm. They outlined this, the judgment. I've got it. It's 27 pages. I'm scrolling through it. This is me for the first time going through this decision and having the opportunity to put eyeballs on this and understand what the High Court has ruled. And they spend the first 5, 6, 7, 8, 9. Let's see. When do they actually rule? Okay. So the first part of the decision comes let's say on page 13. So nearly half of this decision is a summary of how we got to this point, according to the High Court. We have Mr. Assange has put forward a substantial bundle of material to support these submissions. We accept that we should receive the evidence, which is in admissible form, put forward in response to assurances offered only at the appeal stage. General statements of opinion calling into question the good faith of the USA from those who establish no relevant expertise to give such an opinion are of no more value than a journalistic opinion culled from an internet search. Okay. A diplomatic note or assurance letter is not evidence in the sense contemplated. It's neither a statement going to prove the existence of a past fact, nor a statement of expert opinion or a relative matter. And then they reference a prior case that I'm not very familiar with, but it's India v. Deere, a recent one. The district judge refused to admit it when to do so would result in a further hearing and in further delay to proceedings. In our view, a court hearing in an extradition case, whether at first instance or on appeal, has the power to receive and consider assurances whenever they are offered by a requesting state. It is necessary to examine the reasons why the assurances have been offered at a late stage to consider the practicability or otherwise of the requesting state having put them forward earlier. It's also necessary to consider whether the requesting state delayed the offer of assurances for tactical reasons or acted in bad faith. If it has, it could be a factor which affects the court decision whether to receive the assurances. If, however, a court were to refuse to entertain an offer of assurances solely on the ground that they had been offered at a late stage, the result might be a windfall to an alleged or convicted criminal, which would defeat the public interest in extradition. Moreover, as lead prosecutor Mr. James Lewis pointed out on behalf of the USA, a refusal to accept the assurances in this case on the ground they had been offered too late would likely lead to delay and duplication of proceedings. If the appeal was dismissed on that basis, it would open the USA to make a fresh request for extradition to put forward from the outset the assurances now offered in the appeal. So they're going along with this idea that the judge should have asked for the assurances when she had made the conclusion she would rule against the decision. Then this High Court points out, we observe that the decision that all closing submissions should be made in writing in a case in which the arguments are ranged far and wide over many days of hearing may well have contributed to the difficulty faced by the USA in offering suitable assurances any earlier than it did. Okay. There's no evidence to support that, but that's their interpretation. Had there been an oral hearing, even if only a short one, supplementing the detailed written submissions, we think it very likely the USA would have been able to identify the issues which appeared to weigh most heavily with the judge and to request an opportunity to offer suitable assurances if necessary, as it was the issues to which any such assurances might relate only crystallized when the judge provided counsel with a draft of her judgment. We think it would have been better at that stage had the judge offered the USA the opportunity to consider providing assurances rather than proceeding straight to the discharge of Mr. Assange. Had she done so, we have no doubt that the USA would have offered the assurances before the final decision was made. I'll have to go back, but both parties agreed to these closing submissions, and neither believed that those closing submissions being in writing and not having a hearing where we heard closing arguments in open court would get in their way of being able to succeed and prevail in the case. Well, they definitely did not anticipate that the district judge would take Julian Assange's mental health as seriously as she did. And so the High Court continues. We are satisfied that we can receive the assurances notwithstanding the stage of proceedings. So they have no problem with accepting those assurances. The first and fourth assurances wholly exclude the possibility of Assange being made subject to SAMS or detained at ADX, that's a supermax prison, either pretrial or other conviction, unless, after entry of the assurances, he commits a future act which renders him liable to such conditions of detention. It's difficult to see why extradition should be refused on the basis that Mr. Assange might in future act in a way which exposes him to conditions he is anxious to avoid. Of course, that statement suggests that there's nothing political to this case. That's the position of the High Court, is that everything is being done and there's nothing controversial about what the U.S. is pursuing. Though, if you ask civil society organizations, they'll tell you differently. If you ask the press, they're not that supportive of what the U.S. is doing to Julian Assange, though they may not like Julian Assange. So they say that Mr. Assange might like to avoid being put in a supermax and SAMS. There's basically suggesting that the U.S. government should let me backtrack. That Julian Assange's team thinks the U.S. government should tie its hands behind its back, allow Assange to commit future acts that normally they would put him in a supermax prison or put him in SAMS to prevent. And that this is just some way to game the extradition process for Julian Assange's benefit. We've seen ridiculous things like this said by people all along the way, including things like Julian Assange's making up his mental health symptoms by reading the British Medical Journal, a real argument by the chief prosecutor for the Crown Prosecution Service. So the second assurance is about consenting to an application for transfer to Australia. And they say the possibility that Australia may not be willing to receive a transfer cannot be a cause for criticism of the USA or a reason to regard the assurances as inadequate to meet the judge's concerns. We have that the third assurance is an undertaking that Assange is in custody in the U.S. He will receive appropriate clinical and psychological treatment, and they find no problem with that. So they say, we see no merit in the criticisms made of the individual assurances. The reality is that this court is being invited to reject the USA's assurances either on the basis that they are not offered in good faith or that they are for some other reason not capable of being accepted at face value. That's a serious allegation, particularly bearing in mind that the United Kingdom and the USA have a long history of cooperation in extradition matters, and the USA has in the past frequently provided and invariably fulfilled assurances. So then they mention some cases and go through. So what the High Court is saying is we have to think about diplomatic relations between the United States and the UK. We work closely together. We are allies. We have to allow this Assange case to go forward because we are close allies. That's what the High Court is saying. Mr. Assange seeks to counter that approach. Then they go through cases that were submitted. Two cases, which I'll save for another time, were David Mendoza and Abu Hamza's case because of the way the U.S. went back on assurances in those cases, they do not believe that those are reason to doubt the assurances in Assange's cases. So there is no reason why this court should not accept the assurances as meaning what they say. There is no basis for assuming that the USA has not given the assurances in good faith. They're very clear. This is on 17. So we've got like 10 pages left in this ruling, and they lay it out very clearly that they have no doubts about what is being said and offered by the U.S. government. No questions. Zero questions about the U.S. and whether you can trust their assurances. We are satisfied the judge based her decision on her findings of a real risk of Mr. Assange being subject to SAMs and or detained at the ADX. That risk is in our judgment excluded by the assurances which are offered. It follows that we are satisfied if the assurances have been before the judge, she would have answered the relevant question differently. That being clear, we do not accept the submission on behalf of Mr. Assange that the case should go back to the judge for her to decide the relevant questions afresh. So at that point, they're saying, we know your request to us was if we see the assurances as reasonable, that you should be allowed to have a hearing before the judge on the assurances or before the district court on the assurances. We don't think you should be granted that because all the evidence was there and she was able to rule. So we have ground one, which is on whether the extradition law was interpreted correctly. And to ground one, they reject it. So they decide that the judge applied the law correctly in making the determination. Basically, she applied a test known as the Turner test to come to the conclusion that it would be oppressive for mental health reasons for Julian Assange to be extradited. And they do not question the judge on that ground. Grounds 3 and 4 involved this professor, Michael Kopelman, who is unfoundedly and obscenely attacked by the Crown Prosecution Service. They said things about him that went after his professional reputation. And the High Court, says of those things, such as his alleged misleading of the court, that, and this is a much longer section. I'll come back and look at this, but they say, in our view, Professor Kopelman plainly did not comply with those statements because in her first report, he chose not to state what he knew of the relationship between Mr. Assange and Ms. Morris when opining on the effects of Mr. Assange's solitary confinement in the embassy and the risk of suicide. And subsequently, he failed to correct his report or to make clear his earlier knowledge of the relationship. We regret to say that declaration was simply untrue. On the contrary, the second report did nothing to correct the misleading impressions created by his first report. It maintained a silence about knowledge at the time of the first report. We cannot agree that the finding against Professor Kopelman should be excused or overlooked as an understandable human response. That's what Judge Baretzer had said. We think there are substantial reasons for the judge to question the impartiality and reliability of Professor Kopelman. We would have expected to see a rather fuller analysis than she gave of her reasons for deciding she could accept as evidence. Question for this court, however, is whether she was entitled to accept as evidence. It is clear that Dr. Deely's evidence was influential as well as Professor Kopelman's evidence. Whether the mental condition of a requested person is such that it would be oppressive to extradite him is inevitably a fact-specific decision, respecting, as we must, the judge's findings of fact and evaluation of the evidence. We reject grounds 3 and 4. But not before telling you that we actually don't like part of how she ruled. You know, then in a backhanded way, we'll accept how she treated it. We'll further the scurrilous attack on Kopelman by saying there is some basis to what the Crown Prosecution Service was doing. but we are not going to co-sign it entirely. Okay. So there's some additional parts here. We're on the last page finally, and they were satisfied that federal prosecutor. Okay, so they're pointing to the district judge saying that Assange's case was brought in good faith because there are arguments in the judge's ruling about abuse. And she said that I reject the defense submissions concerning staying extradition as an abuse of the process of this court. So the High Court adds, it's unrealistic to suggest that she left unresolved an issue which could properly have been decided in Mr. Assange's favor. We accept the submission of the USA that the DJ determined all issues raised as an abuse of the process. This apparently relates to something about his Article 3 rights, and it's kind of weedy and maybe, beside the larger point that they have overturned the extradition decision. Conclusion, we reject the grounds 1, 3, and 4. We allow the appeal on grounds 2 and 5. So 2 of the grounds. We accordingly quashed the order discharging Mr. Assange, so he would not be released. But remember, he was denied bail by Vanessa Baretzer. We remit this case to the Westminster Magistrates Court, direction to proceed as the district judge would have been required to do if she had decided differently. The relevant question of whether Mr. Assange's mental condition was that it would be oppressive to extradite him, namely by sending the case to the Secretary of State. So it must be passed along to the Home Office, which I said earlier in this broadcast was the office that originally authorized this extradition to be considered by the court system. So the Home Office says this is a legitimate extradition request. It goes before a district court, and the district court looks at it, signs off on it, and then it comes back, and the Home Office gets to then be the watchdog or the person who checks to make sure that it was all legitimate. But it's like essentially a feedback loop. They're all going to reinforce each other. The judge is going to lean on the Home Office. The Home Office is going to lean on the judge. All right. Well, let me see what some of you have been saying, and if there's anything that is worth responding. If you've got any questions or comments for me, please drop those. But it's time for me to go write a report. I won't be breaking the news, but I need to do my analysis of this and its implications. The basic implication is Assange is not free, but the wider thing is to understand what was embraced and believed entirely by the High Court, and then what was rejected. What do we need to spend our time focusing on? These assurances are obviously something that we need to do more to show why they are not to be believed. If the Supreme Court were to not allow the appeal or the super chat, where is my super chats? I should have those on. 1 second here. Allow me to see if I can turn this on. We weren't monetized. I have to sign in to this. I'm one person, so be patient with me. Someone has brought up that we do not have super chats turned on. And the good news is that recently YouTube looked at us and verified our identity and granted us access to money that had been given to us months and months ago. but they weren't able to verify our address because they have a system that was disrupted by the pandemic. So we never got, we weren't able to do this. We had super chats for a while and then they turned it off because we had not verified our account. So I can turn this on and enable it. I don't know if you're going to suddenly see it. I can do this. So I see all the people here who have given me super chats and stickers previously, and I thank them for it. Only recently were we able, and actually since I don't have it yet, but I've turned it on. If you're able to, I don't think it's going to be something that I can add to this video, but if you're really motivated, you can go to here. If you're really motivated to give and support this work, you can go to this website here. It's not the Dissenter newsletter, but it's my organization's website. And you can give small sums. It won't go through Google, and we'll get it. And if you want to make a note that you're donating for Assange coverage, or you're donating because you watched the Assange broadcast and you want more broadcasts like this, and you want more coverage of the Assange case, et cetera, you can give you can throw a few bucks this way. You can leave tips this way if you would like for it. So maybe direct your super chat there today if you would like to give. Thank you if you do decide to do that. Then in the future, we should have something made available. But there's apparently another hoop or two that I have to jump through in order for YouTube to grant me access to the super chats. We'll take care of that later on. But enough of that. All right. Let me see if I can make this simple. I've got a question here. Mikey is asking, can you give it to us in simple English? Has the British High Court approved Assange's extradition to the USA, or have they rejected their appeal? So the answer is they have approved the USA's extradition. They have approved it. They have approved it because the US government offered diplomatic assurances related to how Julian Assange would be held in confinement. And they approved it because they believe that those assurances were offered in good faith. And even though they came after the district judge ruled, they believe the district judge made an error in her handling of the case and should have come to the Crown prosecutors and said, I'm going to rule against your case. What can you say to persuade me differently? And then they would have maybe offered assurances about how Julian Assange would be treated. And then she would have factored those in, and she would have had to, they claim, this is the High Court's claim, she would have had to allow the extradition. So that's what I hope that makes sense. If that doesn't make sense, Mikey, let me know before I log off here. So drop my Patreon. Well, I do a show. Oh, I know. You want me to share the Patreon for Shadowproof. There is also, yeah, a person here mentions this. This is also a way to support. If you don't want to make your donation go through the Google machine, you can put it through this not as bad machine. They still take a tiny bit, but we always get our Patreon payments, so you can do it that way too. All right, so questions. Anything else? And I see the super chat is restored. So thank you, Faint Signals, and it's there. See somebody commenting on the Democracy Summit. Yep, that's a joke. The British courts are ignoring the blaring injustice and taking the easy route of ticking boxes. They don't care that justice is not done. They've just followed the rules, which are themselves unjust. That's a really good way to put it. If Julian loses the appeal to the Supreme Court, well, then that'll go to the Home Office, and the Home Office will allow the extradition. Of course, the CIA was considering how to assassinate him. Is of no concern. I read through the whole ruling, and I'd have to go back and look even more closely. But on skimming through, I didn't see any mention of the things that were raised in the context of the Yahoo News report, which we spent an afternoon during the High Court of Justice appeal hearing going through. Someone on here has as their representative Adam Schiff. You're in trouble because Adam Schiff is actually openly in support of this extradition case. So, I mean, I'm not really being fair to members of Congress when I say that they've been silent. Some of them, like a dozen or so, did indicate that they like that this case is going forward. And then they've been silent ever since because there's not more to say. Australia is just a U.S. puppet state, and Crystal, Marion, Bree, and Katie need to snap into action. It's a good reference to these 4 podcasters who are very well known in the United States, got together and did a Stephen Donziger, and have done free Stephen Donziger podcasts, and that they should do one for Assange. I've been part of something like that with them to free Assange. It's time. We organize calls to the Justice Department. It's probably time to do more of that. Although I don't do a whole lot of advocacy, I tend to be pretty focused on the journalism that is necessary here and pushing out coverage of this. But yeah, so happy Human Rights Day, everybody. This is not how I plan to celebrate it. I don't know if you celebrate Human Rights Day. It does seem like a day that governments came up with so that they could excuse or get like for one day they all make an informal pact not to to only criticize a certain set of countries that have been agreed upon as those countries are the ones we're really going to focus on shaming. So like Belarus, and let's talk about Nicaragua, and we'll talk about Russia and China, and let's make sure we don't forget the Taliban in Afghanistan, who U.S. military occupation allowed to take over their country, and then I don't know, probably a couple countries in Latin America that we could throw in there, throw in an African country for good measure, probably South Sudan, and then those are the countries we'll all talk about amongst ourselves. And let's keep the European countries out of this. They're our friends, and that's Human Rights Day for everyone involved. And so anyways, I'm very depressed. No, I don't think that's the right word. I move forward with renewed vigor and interest in challenging this case. It's not the time to fold and say that they've won. We have not lost. As long as Julian Assange has not been brought to the United States, the people in global press freedom organizations, the human rights activists, the supporters of Julian Assange, the team for Julian Assange, Julian Assange himself. They are still able to fight this and make an outcome happen that is favorable. And so let me say as I close, thank you, Steve, for your donation. Thank you. Really honored and glad that there are people out there like you who, well, if you are able to give, do give. If you can't give, there is no reason to tell me and apologize. We all have our limitations, and I'm not here to make anybody feel bad if they can't support this work. The only thing I ask is that you be here and participate and engage with what I do. And many of you here are, and I'm really grateful. And you talk about this broadcast, and I'm also pleased that the people who follow along and the comments that I see, that you're talking about the Assange case and not going on about other things that have nothing to do with what is at stake here. And you're sharing this, you're letting people know where they can find this work. I see many people sharing the thread to my coverage of the Assange case. It's time to wrap. Did somebody say you got married? Yeah, somebody did say I got married. I don't know where they got that news because I've been married for more than 5 years now. I got married in 2016. Celebrated a 5th wedding anniversary this year. It was a while ago. Julian Assange and Stella Morris will hopefully be having a wedding. And I think that's something human that they can have. They should be able to do that in the next few months. It's important for them to do that. They should be allowed to have that bond so that they can go forward. And this is a hard struggle. We're all here for trying to stop this political case from going forward against somebody who should be protected, should have First Amendment rights. And they should not be allowed, the U.S. government should not be allowed to engineer and manufacture case law in a way that makes the Espionage Act a tool that can be used to control journalists in the United States. That's the plain fact. That's the position. That's what we should say. The way in which this case is being used to do potentially irreparable damage to open democracy, human rights, as well as freedom of the press, has to be opposed. Opposed, full stop. So I'll be sending out my updates, reporting on Julian Assange and this appeal decision. It'll go out in the next several hours. There may be another stream from me. I may have another conversation that I do with some other voices later. But until then, thank you all for tuning into this broadcast. If you're up early in the US, thank you for joining me. If you're in Australia or the UK or other parts of the globe, thanks for tuning in wherever you are. I'll see you around.